Yesterday, the MK party argued in an urgent interdict application in the Johannesburg High Court for an interdict against the Judicial Services Commission's sitting starting on Monday. The court today released its judgment dismissing the application of the MK party. Yesterday, the Western Cape High Court had given the MK party a date to hear its leave for appeal application, trying to appeal and review rather the outcome of the Part A application in the Hlope matter, as we will call it for now, pertaining to his status as a commissioner on the Judicial Services Commission. Spokesperson of the MK party, Nhlamulo Ndhlela, is here with us. Nhlamulo, what is the plans of the MK party? Monday is very close by. There's not much jurisprudence it can draw on to appeal an interdict application, especially the one coming out of the Johannesburg High Court. Are there political means that the party is exploring regarding Monday's sitting?
Well, we have to look at it in two fronts and look at what are our options, both politically and legally, if there is. And that's what we've been discussing with our legal team to identify what avenues do we have. And we'll then communicate that, as we mentioned in our statement, tomorrow, effectively.
Yeah. Of course, you would have had a precursory engagement with your legal team. There isn't much jurisprudence, like I said, to draw on. Appeals on interim interdicts and appeal on interim relief, rather, is very thin. And in very exceptional circumstances do they pass by. On the political end, what engagements is the party having with not just the Commission, but also the Speaker of Parliament to remedy this, if at all?
Well, you mentioned, unless in exceptional circumstances, that in of itself, by use of that word, could effectively mean that there could be a legal avenue of some sort. Here's the reality. Unconventional circumstances call for unconventional measures. And we need to then identify, based on the current circumstances,
what are the options?
What those options are. And as you would have known, we've only received this judgment as of today, this afternoon. And this is not, it's a complex matter. It's not a matter that you just jump into. There's a lot of sensitivities that we need to take into consideration. Because again, we want to work and ensure that whatever decisions we take are within the law, whether it be the program of action or even the legalities that are available to us, if they are.
The Commission chairperson has made it quite clear that the Commission will sit on Monday, now that there's an outcome on this, and they will go ahead with their interviews. Will Dr. Hlope arrive at the Commission chambers on Monday?
Well, here's the sad part. I don't know which judge would want to be interviewed off the back of a sitting that is marred and blemished with a process that is quite honestly unconstitutional. Unconstitutional in the sense that it has infringed on Dr. Hlope's rights. It has infringed on MK Party's rights. Dr. Hlope has the right, by virtue of him being a member of Parliament, to participate in any committee, such as the case is
the Judicial Service Commission is not a committee, it's a commission.
Well, it's the same. He was voted in. They're democratic. I'm saying the process. The process and the powers and privileges allow him as a member of Parliament. When I say it's the same, I'm saying it's the same in terms of us nominating him to participate in a committee or even a commission. In this case, the commission, yes. But the fact of the matter, the essence of the matter here is, can he participate? Does he have the right to participate as a member of the National Assembly? And we're saying yes. Now, what has happened is the DA has gone and sought an ad hoc process based on morality to stop him from participating. And we're saying that the Parliament has already taken its decision for him to participate. That's that. That's where it ends. Why gerrymander the law to suit your own political agenda? And that's what's happening here.
You seem to make the point that he has an inherent right as a member of Parliament to serve on any structure that the party deploys him to. And it is his right, if the party deploys him to serve on any structure, that he will then serve on that structure. But there are exceptions in Parliament that we've seen in the past. One exception, for instance, is the Portfolio Committee on Intelligence. It doesn't allow just anyone to sit on there. In fact, that committee has to go through a very extensive vetting system, and parties have had in the past their members rejected from being able to sit on that committee because of past transgressions, such as, for instance, concerns that they may leak sensitive intelligence information, because that's what that committee deals with. This is why that committee's work is not published, it's not broadcasted, and happens clandestinely away from other members of Parliament. Yourself, you're a member of Parliament. If you don't serve on that committee, you'll have no idea what happens on that committee. So there's no inherent right to serve on any parliamentary structure your party deploys you to.
I think where you are correct is the following. You've just defined and well articulated the difference between sitting in intelligence committee. You said it yourself, because of the sensitivities that come with intelligence. And remember, before you even sworn in to sit in intelligence, you actually have to be sworn in for the second time to sit in intelligence.
Yeah.
Here, you don't have to be sworn in. This is not a swearing in. So you've just defined exactly
the point
why
I was trying to make is that there's no blanket inherent right to serve on any parliamentary function.
I'm saying to you, before it actually gets constituted as an intelligence committee, it firstly becomes a joint intelligence committee in an ad hoc basis.
Right.
And then people are nominated to sit in there from the various parties, okay? Allocated seats according to whatever representation percentage-wise you have in your vote in parliament. And then you have the first sitting, and then after the first sitting, what then happens is they then do the vetting process, right? Now, if you either make it or you don't, then that's a different situation. Here, this is a man that's going to preside based on his qualifications and his right as a member of parliament to sit in there and effectively oversee and preside over interviews. He doesn't make a decision. He's going to be there to recommend an interview. Remember, the powers are vested within the president to make a final decision in terms of who he wants, regardless of whatever recommendation is made. So we cannot compare, the Judicial Service Commission with intelligence. That is a totally different.
So you concede that there is no blanket right to serve on any parliamentary structure your party deploys you to?
I'm saying to you, you can serve in any committee as long as, and you're saying it yourself, it's not some court process that is making a determination as to whether I can be part of intelligence, for instance. No, it is an internal process within Parliament that is looked at in terms of the vetting process, and there's a certain process. It's not me or some other court process that arbitrarily comes with a solution and tells me a morality that I can't participate in that. No, by virtue of me being a member of Parliament in the first place, I have the right. And the mere fact that, by the way, you could even have, and this is what the reality is, you could actually even have a criminal, a person with a criminal history, sitting in the initial joint intelligence committee until such a vetting process is concluded. But you don't just reject him before you've actually taken him through a process. And that's the same thing here. We're saying they must postpone this sitting until Dr. Hlophe, as per the 1st of November, until that process is concluded.
Yeah.
And then, because before then, it'll be put in the cart before the horse. And the reality is the following. Whichever judge is appointed off the back of this process will be blemished.
Just 30 seconds quickly, because we are very thin on time. You seem to agree with the court in the Western Cape High Court in this instance, that Parliament doesn't just rubber stamp. Parliament has to actually go through a process to determine the suitability of candidates in certain instances, not a portfolio committee, but a commission, or in the instance of an exceptional case, the Intelligence Committee. That's what the court says. You agree that Parliament doesn't just rubber stamp, Parliament has some work to do. Do you believe that Parliament has done sufficient work in the instance of Dr. Hlophe's suitability for the Judicial Services Commission?
Where has it ever been insufficient with all the other Judicial Service Commissions? Where?
Okay.
How? They all follow a process. We followed the same process. Yeah. And there was a vote. Nothing. There's no dichotomy between what happened here and the previous JSC.
Fair. And just lastly, what is happening this week is there's an extra layer of controversy and exceptionalism here, is that the Commission will be taking interviews and considering candidates for the appointment of Judge President for the Western Cape High Court, the position from which Dr. John Hlophe was expelled from. Now, there's a question about the suitability of him, even if there was no impugned judgment on his suitability, to serve on those interviews, specifically given that he would have had a tense relationship or a friendly relationship with some of the candidates in that division that would be interviewed for Judge President position. It makes him conflicted nonetheless, does it not?
No, I think what you're doing is, you're conjuring up a character that Dr. Hlophe is not. So you're creating all sorts of perceptions and possibilities. I'm
not conjuring it up. It is the actual outcome that says he has low integrity.
No. How does he not have integrity? I think what's important to understand and inform South Africans is, what is the basis of this impeachment, the so-called gross misconduct? All he did was he communicated with his colleagues and said, gentlemen, this is out of my hands. This is out of my hands.
You're not going to re-litigate it. This is now out of my hands.
It's in your hands to resolve it accordingly.
Yeah.
That's all he did. That was his only comment.
Neither you and I,
so on the basis,
in a position to interrogate the tribunal's outcome.
So on the basis, but that's what you've just done. You've just interrogated it and you've given it credence, which is not there. You've given it credibility that's not there. We're saying that does not in any way impede in his competence. The man has sat in court for 28 years. In actual fact, who better?
It's not his competence that is in question, it's his integrity.
No. Who better? But integrity based on what?
Okay.
Based on what? The reality is the following. He is competent enough to preside over that. The biggest challenge that they have is that he is going to scupper their agenda.
Yeah.
Because you know what? Where he exists, they don't excel.
Yeah. Nhlamulo, thank you so much for your time. That is the MK spokesperson.